The Hiring Process, Part 2, Employment Law. In this module, we will be discussing laws that regulate the hiring process. Our objectives: upon completion of this module, the participant will appreciate the complexity of laws related to the hiring process. They will understand the intent of several of the most influential laws. They will understand how these laws affect EMS hiring decisions. The most important legal concern during the hiring process is that you do not discriminate against individuals or groups of applicants. Numerous laws have been enacted to prevent such discrimination. As you can see from this list, there are numerous laws that influence the hiring process. Most of the laws of concern in the hiring process are centered around preventing unwarranted discrimination. As can be seen from this list, there are laws to protect against discrimination due to age, disabilities, religion, sexual origin, and citizenship. There are also specific laws to protect the rights of veterans and women who are pregnant. Let's take a look at several of the most influential laws. One of the first laws to affect the hiring practice was the Civil Rights Act of 1964. This act has two essential components. First, it made it illegal to fail to hire, refuse to hire, or dismiss any employee based on race, color, religion, sex, or national origin. It also made it illegal to segregate applications or applicants based on these same factors of race, color, religion, sex, national origin. Another thing that came out of the Civil Rights Act was the classification of protected classes. Protected classes are groups of specifically identified individuals that require special protection to prevent against discrimination. Also arising from the Civil Rights Act was the EEOC, or the Equal Employment Opportunity Commission. It's likely that if you've been involved in the hiring process, you've actually had to integrate or interact with the EEOC. The EEOC oversees special circumstances, especially when there's any claim of discrimination. Finally, the Civil Rights Act required the maintenance of employment records, thus requiring employers to maintain records that could prove there was no discrimination involved in the hiring process. Another concept that arose out of the Civil Rights Act was the concept of bona fide occupational qualifications. The Civil Rights Act did leave room for special situations that require a specific individual. An example may be the production company who needs a female to play a female role. In this situation, it's legal to only interview females for the position. They are the only candidates that can accurately or appropriately fill the role that's being looked for. However, you should be careful. If you determine that you need to discriminate for a position, make sure that there is an absolute necessity and that it passes the bona fide occupational qualifications rules. Another law that has influenced the hiring process is the Age Discrimination Act of 1967. This act makes it illegal to discriminate against employees based on age. Specifically, it applies to individuals that are 40 years or older. As the pool of EMS applicants decreases, it's likely that we will see more and more older individuals applying for EMS positions. Because of this law, it is important that you not discriminate against these individuals in any way during the hiring process. A good practice is to not even look at the age when determining an applicant's employability. Another law that often creates particular interest, or is of particular interest, to EMS organizations or EMS providers is the American with Disabilities Act of 1990. Title I of the American with Disabilities Act, which took effect in 1992, prohibits discrimination against qualified individuals with disabilities. An individual with a disability is a person who has a physical or mental impairment, has a record of such impairment, or is regarded as having such an impairment. A qualified employee or applicant with a disability is an individual who, with or without reasonable accommodations, can perform the essential functions of the job in question. Reasonable accommodations must be provided. There is an exception. If hiring a disabled individual creates an undue hardship on an organization, there is some relief from this act. This will be discussed later in this module. There are certain exclusions to the ADA, or the American with Disabilities Act. These include homosexual and bisexual situations, compulsive gambling, pyromania, kleptomania, illegal drug use, sexual behavior disorders, threats to others in the workplace, again, undue hardships, and gender identity disorders. It's very important in these situations that you seek legal counsel if there's any concern or any question about the eligibility of a potential employee or applicant. Another issue that commonly arises in EMS is related to pregnancy. The Pregnancy Discrimination Act of 1978 makes it illegal to discriminate based on pregnancy, childbirth, or related conditions. In these situations, pregnancy is considered to be a temporary disability and should be treated just like any other disability that would exist within an EMS organization. Individuals that are pregnant cannot be required to leave work during pregnancy unless they're unable to perform their job. However, the Act does not require any special accommodations for pregnant employees. One area that deserves special attention is that of the issue of affirmative action. Affirmative action involves implementation of specific policies aimed at creating equal access to employee opportunities for historically minority groups. More specifically, these policies may dictate the ratio of employees based on gender or sex. For example, an organization with an affirmative action policy may give special preferences to hiring Hispanic females. A concern with the creation of affirmative action policies is that they can lead to reverse discrimination. Affirmative action is only legal when it doesn't unnecessarily hurt the interest of other employees, when it doesn't exclude non-covered individuals as a group or class, when it's temporary and flexible, and when it's based on the concept of disparate impact. Disparate impact involves the ratio of which individuals should be hired from minority groups. As you see, there are numerous legal issues that must be considered in the hiring process. As we start to discuss the selection process in more detail, keep in mind that it is essential that you clearly identify the essential functions of a job. Refrain from asking about disabilities, except in the context of its influence on job performance, and that you need to refrain from asking about specific issues that can be considered discriminatory. In this module, we have reviewed the numerous types of recruiting laws that affect recruiting and hiring. Next, we discuss the ways in which the recruiter can influence the recruiting process. In Part 3, we will take a closer look at specific questions involved in the interviewing process.